5 seconds to go. Start. In several instances, such interim orders also have impeded the making of an award, para. The litigation initiated by the landowners has to be decided on its own merits, and the benefits of Section 24(2) should not be available to the litigants in a straitjacket manner. In case there is no interim order, they can get the benefits they are entitled to, not otherwise. Delays and dilatory tactics and sometimes wholly frivolous pleas cannot result in benefiting the landowners under subsection 1 of section 24 of the Act, 2013. Para. Any type of order passed by this court would inhibit action on the part of the authorities to proceed further, when a challenge to acquisition is pending. Para. Interim order of stay granted in one of the matters of the landowners would cause a complete restraint on the authorities to proceed further to issue declaration. When the authorities are disabled from performing duties due to impossibility, it would be a sufficient excuse for them to save them from rigor of provisions of section 24. A litigant may have a good or bad cause, be right or wrong, but he cannot be permitted to take advantage of a situation created by him by way of an interim order passed in his favor by the court at his instance. Although provision of section 24 does not discriminate between landowners, who are litigants or non-litigants and treat them differently with respect to the same acquisition, it is necessary to view all of them from the standpoint of the intention of the parliament. Otherwise, anomalous results may occur and provisions may become discriminatory in itself. Para. The law does not expect the performance of the impossible. An act of the court shall prejudice no man. When there is a disability to perform a part of the law, such a charge has to be excused. When performance of the formalities prescribed by a statute is rendered impossible by circumstances over which the persons concerned have no control, it has to be taken as a valid excuse. Para. The court can, under its inherent jurisdiction, ex debito justitiae, has a duty to mitigate the damage suffered by the defendants by the act of the court. No person can suffer from the act of court, and an unfair advantage of the interim order must be neutralized. No party can be permitted to take shelter under the cover of court's order to put the other party in a disadvantageous position. If one has enjoyed under the court's cover, that period cannot be included towards inaction of the authorities to take requisite steps under section 24, as the state authorities would have acted and passed an award determining compensation but for the court's order. Para. Therefore also, the original writ petitioners - landowners shall not be entitled to enhanced amount of compensation under section 24(1)(a) of the Act, 2013 on the ground that, as the award has not been declared, they shall be entitled to compensation under the Act 2013. Para. In view of the above and for the reasons stated above and our specific finding that with respect to the lands acquired under the provisions of the J&K Act 1990, section 24(1)(a) of the Act, 2013 shall not be applicable.